Gentlemen and ladies, may I welcome you all to this new series, designed to discuss different topical issues in international arbitration. I am Professor Joshua Ronald, and will be leading the discussion on the different topics, along with the Bayame and Anita, who you shall meet soon. I shall provide a brief introduction for each session and allow our commentators to debate the core issues implicated by the different topics. These series shall cover discussions on third-party funding and international arbitration, reform of investor-state dispute settlement, debate on creation of multilateral investment court, enforcement of arbitral awards and debate on reform of the New York Convention, corruption in the context of investment arbitration, arbitration of oil and gas disputes, investment protection and environmental disputes, amongst other issues. Today, we will start with third-party funding and international arbitration, a subject which has become one of the major topics of discussion and interest within the global arbitration community. Third-party funding is an arrangement between a party and the funder, whereby the funder agrees to cover the costs of prosecuting a claim in exchange for a percentage of any proceeds derived from the arbitral proceedings. Typically, third-party funding is offered on a non-recourse basis, and the funder's recourse for repayment of the capital advanced and return on the capital invested is limited only to the claim proceeds recovered. Third-party funding is now common in both commercial and investment arbitration. Despite the systemic benefits of third-party funding, there are concerns about the ethical and procedural issues thrown up by the funding arrangement. I will now yield the floor to our commentators to debate the following questions. So, let's start with the question, why is third-party funding useful or should it be abolished? Thank you, Professor Ronald. Third-party funding is useful and should not be abolished. As international arbitration continues to develop, so are the procedural complexities and the attendant costs. Sometimes, the costs of discovering, screening and presenting detailed, factual and technical evidence can be unavoidably steep and prohibitive, such that valid and meritorious claims may never be commenced or conveniently proven. Third-party funding is useful in facilitating claims that have merit, but would otherwise not be pursued, simply because of the significant cost. Claim holders may also consider third-party funding, as it lessens the impact on cash flow and minimizes the risk if the claim is unsuccessful. Cost and risk are the two factors most often cited by potential claimants as having been critical in a decision to look for arbitration finance. There may also be a significant impact on accounting, since the arbitration costs paid by the funder will not be recorded in the balance sheet of the funded company. It may also be used to finance portfolio of cases and helps to distribute risks across multiple disputes, with the high-value claims used to collateralize other cases. As noted by Professor Albert Jan van den Berg, international arbitration should not be justice for the rich only. Third-party funding is now an unavoidable commercial reality. Therefore, rather than crushing the best thing since sliced bread, I argue that countries, institutions and professional bodies should establish appropriate rules to balance the costs and benefits of third-party funding by minimizing the costs and maximizing the benefits.
Thank you, Professor Ronald. I disagree with Abayami. Third-party funding has the potential of stirring up frivolous cases and increasing the number of unmeritorious cases. Furthermore, the existence of third-party funding adds an extra layer of complexity to settlement discussions, the argument being that the interest of the funder in the outcome of the claim may affect potential settlement figures. Also, there are concerns about the funder's influence on attorney-client relationship. Typically, funders wield power to appoint or remove attorneys and may influence the nature of evidence or conduct of proceedings. In fact, the U.S. Chamber Institute for Legal Reform released a paper in October 2009, which advocated for restrictions on third-party funding in the United States on the basis that investors exert overbearing control over litigations. In investor-state dispute settlement, the policy issues implicated by third-party funding are intertwined with the political debates on the legitimacy of the process, and third-party funding is regarded as exacerbating the basis for these debates. Many also argue that it is inappropriate for specialized hedge funds to profit from arbitrations, especially when the profits they recover from successful claims come at the expense of developing states. The foregoing said, it is not even clear if third-party funding is legally possible in most jurisdictions, due to the impact of the common law doctrine of champerty and maintenance. Maintenance is the financing of a case by a person who has no connection or interest in the case. Champerty is an aggravated form of maintenance. It is the financing of a claim by a person who has no connection to the case other than the pecuniary interest in the proceeds. These doctrines are regarded as unethical and contrary to public policy.
Thank you, Abayami and Anita, for the erudition. Really well done. What appears clear from your arguments is that whilst third-party funding is useful, there are concerns on some of the ethical and policy issues implicated by the arrangement. So will you both consider regulation as a way to minimize the risks and maximize the benefits? I agree absolutely, Professor. Third-party funding has become a lubricating superoil for facilitating justice for all. So, what is required is effective regulation of the process. This includes mandatory obligation on disclosure of third-party funding, provisions on allocation of cost and security for cost, and provisions on confidentiality and privilege. The need for regulation was confirmed by the survey respondents in the 2015 Queen Mary School of International Arbitration Survey, the Queen Mary Task Force Report on Third-Party Funding, and by the UNCITRAL Working Committee 3 on Transparency and Investor-State Dispute Settlement.
I do not agree that effective regulation can be achieved in the absence of empirical data on the use of third-party funding in international arbitration. The likelihood of convincing private funders to share proprietary data is low. Also, given the confidentiality that prevails in most international arbitrations, the confidentiality clauses in funding agreements, and the secrecy necessitated by the business model of many funders, it is unlikely that reliable global statistics and effective regulation will ever be possible.
Interesting. And thought-provoking too. Let us see what the different stakeholders will have to say on this. But I must sincerely thank you, Abayami and Anita, for the great debate. So, this is where we will end today's session. We will be back next week to discuss another important topic in international arbitration. Bye for now.
Watch out for subsequent sessions of the class on topical issues in international arbitration. This initiative has been developed by Abayami Okubit to teach the public the basics of international arbitration. There are also series on the basics of international arbitration law and the legal theory of international arbitration.